So we are pleased to welcome you to our webinar on protecting your intellectual property rights online with a special focus on domain name management and dispute resolution. I have the pleasure to co-hosting this webinar with Alissia. Alissia, can you introduce yourself to our audience?
Yes, of course, with pleasure. Hello, everyone, and thank you for being here today. So my name is Shchichka and I'm an intellectual property lawyer. I also work, I work at Novagraph Belgium, and I also serve as a panelist for several arbitration and mediation centers authorized to handle disputes related to domain name. Marc-Emmanuel, the floor is yours.
Thank you, Alissia. And I'm Marc-Emmanuel Mellet, legal counsel at Novagraph France and head of the domain names and online brand protection. As you know, domain names have become increasingly important assets in recent years, particularly since the COVID pandemic, which has accelerated the digitalization of companies. During our webinar, we will try to give you the keys to managing and protecting your domain names and online property rights. In particular, we will answer the following question: how to build a strong domain portfolio to secure your online presence, how to align domain names and trademarks for optimal protection, how to detect and counter cybersquatting and abusive registrations, and leverage legal tools like UDRP, URS, Syreli to recover your domain's names, and how act now to prevent costly dispute. We will end the webinar with a Q&A. Let's get started on creating and managing a domain name portfolio. Alissia, I will hand you over.
Thank you. Thank you, Marc-Emmanuel. So before we begin, a quick question. Do you know how many new domain names are registered every day? So any idea? No? Well, let me help you. There are more than 100,000 new domain names which are registered every day. So in this context, can you protect your trademark while maximizing your online presence? So the goal of this webinar is to show you that an effective management of a domain name portfolio can not only boost your online presence, but also can help you to protect better your trademarks. So to prevent your trademarks from being registered in the domain names for abusive use by third parties, it's important to anticipate and secure key domain names and the most popular extensions. So including securing fundamental extensions such as .com, .net, .org, but also considering extensions that are often exploited by fraudsters like .co, originally reserved for Colombia, or .ei, which is dedicated to Anguilla, but increasingly adopted due to its associations with artificial intelligence. It's also important to see what are strategic country-specific extensions based on your target markets, and anticipate the registration of sensitive extensions like .sox, .sex, etc., to prevent reputational damage of your trademarks. Finally, quick word about typo-squatting, which is often underestimated risk, and with a kind of practice which involves registering misspelled variation of a trademark to capture its traffic and deceive users. So if you try typing Google with EL at the end into your browser, so you will still land on Google, because they anticipated this typo and they secured that domain name extension. So don't hesitate to register common typos and alternative spellings of your trademarks. So as you could understand, I didn't centralized about just the last word about centralized management approach. With really simplify tracking, and it reduce the risk of renewal lapse. So don't it's an option that we highly recommend. So as you can see, brands and domain names are complementary assets, and Marc-Emmanuel will now explain how to ensure a coordinated management of these assets.
Thank you, Alicia. Domain names and trademarks are complementary assets, and their coordinated management maximizes the value and impact of a business. The strategic alignment between these two elements represents a fundamental approach to ensuring a strong and well-protected online presence. This synergy offers several case advantages that, when properly leveraged, can provide a significant competitive edge. First point, trademark identity protection. Aligning domain names with a trademark guarantees a consistent and clear online presence, avoiding any confusion among consumers. For example, a company named Tech Solutions will benefit from owning the domain name techsolution.com rather than opting for a less relevant name like techsolve.com, which could disrupt its visual and commercial identity. This consistency also strengthens trademark recognition and makes it easier for users to navigate directly to the company website. Second point, strengthening legal protection. A well-managed domain name portfolio aligned with trademark is a major asset for business when it comes to defending its right in case of infringements. In the event of cybersquatting or misuse of a domain name, a company with a well-built domain portfolio has better chances of succeeding in dispute resolution procedures. These steps allow for effectively contesting intellectual property right violation and obtaining either the transfer or suspension of the dispute domain name. Third point, access to pre-registration periods. When new domain extensions are launched, usually there is a sunrise period reserved for trademark holder. These early registration windows allow a company to secure strategic domain names corresponding to new extensions before they are made available to the public. This process enables the trademark to stay ahead of potential actors who might to try to register similar domain and capitalize on the existing trademarks recognition. For example, if a new extension like .tech is launched, companies with the tech solution trademark could immediately register techsolution.com before any else competes for it. Fourth point, improving SEO and visibility. Consistency between domain names and trademark is not only beneficial for legal protection, but also optimize search engine ranking, SEO. Search engine like Google prioritize website whose URL match popular and relevant search term. Therefore, having a domain name that exactly matches the trademark improve visibility in search engine, increase organic traffic, and helps to generate greater online recognition. Furthermore, this can strengthen consumer credibility and trust as they know they are accessing the official website of the company. So we've just seen how to build up a portfolio of domain names. Now we will look at how to detect infringement of your domain names and trademark. And for this, I've turned the floor over to Alissia.
Thank you, Marc-Emmanuel. Next slide, please. Thank you. So protection of domain name portfolio begins with monitoring, which helps quickly identify suspicious registrations and respond to abuses. However, before setting up efficient monitoring, it's recommended to conduct a review of existing domains and compile a comprehensive inventory of all domain names owned by a company. So it's important to check all registered extensions and variations. Also list domain name registered by partners like distributors and others. It also allows you to verify that contact information with different registrars is up to date and that renewals are properly scheduled, so that could prevent accidental domain loss. So next, an audit can help you identify risk area. So to see what are the missing domain names, such as different linguistic variation or common typos or unsecured strategic extensions. And Marc-Emmanuel, could you please explain how to find the right balance in a defensive strategy?
So a small question before, do you know how many extensions exist today? So I will help you. According to the YANA database, there are nearly 1,600 domain extensions. This number has significantly increased with the introduction of new generic extensions such as .tech, .store, .app, and geographic ones, broadening the option of domain name registration. The challenge of defensive strategy lies in finding the right balance between excessive and insufficient domain registration. It will be unrealistic and costly to register your trademark under all these extensions. Therefore, it is more effective to prioritize main extensions such as .com, .net, as well as those corresponding to your geographical markets such as .fr or .de. These extensions are the most recognized and provide good coverage for protecting your trademark identity. At the same time, implementing regular monitoring of new domain registrations help quickly detect any attempt at cybersquatting or trademark impersonation. This allows you to react swiftly without having to register every available extension. Once the balance has been found, it's time to monitor new domain registration. The aim is to detect fraudulent registration. Monitoring of third-party trademark. Domain names monitoring services are essential tools for protecting your intellectual property rights online. They allow you to detect in real time new domain registration containing identical or similar terms to your trademark or other elements of your intellectual property portfolio. The goal is to prevent malicious third parties or unauthorized entities from registering domain name that could potentially cause confusion, harming your trademark recognition for misleading consumers. Domain names monitoring goes beyond your classic extension like .com or .net. It's cover almost all domain name registration, regardless of the extension, whether it is a new generic extension like .tech, .store, or geographic extension specific to a country like .rr. This allows for comprehensive monitoring of domain name registration trends, thus identifying any cybersquatting attempt or unauthorized use of your trademark even on the lesser known platforms. Monitoring is particularly useful for detecting registration made by various types of third parties like competitor, but also franchises, employees, partner, or other service provider. Domain name monitoring is an effective way to protect your trademark integrity online and take swift action against potential infringements. By detecting early domains registration that may infringe your right, you can minimize confusion risk and protect your digital reputation before it is damaged. When it's come to setting up such monitoring, the question of its scope arise? Fortunately, Alissia has the answer.
Domain name monitoring should be adjusted to cover all potential risks. For example, while most companies monitor domain names that include their trademarks, they often forget to track the domain names that would include their company's legal name. So to prevent impersonation, or the domain names which would include the key terms related to their business, like the names of their flagship products or some services. When analyzing and responding to alerts detected through monitoring, it's recommended to have the results reviewed by a specialized legal expert to prioritize the necessary actions. So also remember that collaboration between internal teams like marketing or IT and legal helps to better assess both the commercial and legal impact of the alerts. Finally, it's important to avoid false alerts or overreacting to irrelevant results, such as identical or highly similar trademarks, which are legitimately used by entities operating in completely different sectors. Next slide, please. Thank you. Well, go back.
Sorry.
Yes, thank you. So when a monitoring alert is received, it's important to prioritize the level of risk in order to adapt the right strategy. So here there are some recommendations to help you to assess the level of risk. First of all, it's important to recognize signs of fraudulent registration. So, of course, if your trademarks, especially if it's distinctive, is copied identically or with a slight modification within the questionable domain name, this may indicate abusive use. Also, the domain name extension by itself can be a key indicator. So an extension used along with your with your trademark, but an extension related to your industry, like banking or marketing or dot banking, dot marketing, dot furniture, which this would increase the risk of confusion or fraud for your consumers, and therefore it might be quite risky. Also, and don't forget to analyze the domain's online presence. So if a domain name appear inactive, or there is no website which is displayed, there is no active content, which does not necessarily mean that this domain name is harmless. So check the associated mail exchange records. So if they are activated, which means that emails can be sent and received from this domain. So of course, this opens the door to identity theft or fraud attempts, and such as phishing and so on. Finally, it's important to choose the right response strategy, and I'll hand it over to Marc-Emmanuel to explain to us what are the different options available for responding to domain name abuses.
Thank you, Alissia. So the goal is to find the best compromise between protection and cost, and we are going to present the action available to the right holder to stop infringement, starting with the action that it is the simplest to implement and the least costly. Sorry. So first one, monitoring of the URL and or with. Domain names registration, even if they replicate your trademark exactly, may not represent a major risk as they are. This could be the case, for example, when there is no active website or no email server configured. For this reason, setting up URL or and with monitoring may be sufficient to ensure that you are informed of any changes. For example, if a website were to be created, the monitoring service will notify you, allowing you to decide whether to take action or not. Second option, identity, contact information, or eligibility verification. Depending on the extension and registry, there are different ways to try to obtain information about the domain name holder within the EU is often anonymized under the GDPR, and a very favorable interpretation of GDPR for the benefit of the holders. Some registries have implemented procedures that request accessibility, eligibility, or verification of the information provided by domain holders. If the holders are unable to provide the requested proof, registry may go as far as deleting the domain name. Other solution, the shutdown. In some cases, particularly when a counterfeit site exists and there is a significant risk of phishing, it's possible to request the website closure. This procedure is particularly effective for quickly ending the infringement, but it will require further follow-up or other measures depending on the case. And lastly, the dispute resolution procedure. Dispute resolution procedure are extrajudicial process before arbitration tribunals. These procedures are the advantage of being cheaper and faster than legal actions, and they typically take no more than 2 or 3 months to reach a decision. There are many different procedures depending on the extension, but the best known are the UDRP complaint, the Uniform Rapid Suspension, or the French Syreli complaint. For this procedure, it is generally necessary to demonstrate 3 elements to obtain the transfer, cancellation, or suspension of the domain name. First, element holding an identical or similar trademark to the domain name. Second element, lack of legitimate right or interest. And third element, bad faith, registration and use. Alissia will go over the 3 elements in detail, but first I would like to say that we are very lucky today because Alissia is a panelist at WIPO. She's one of the people who make decisions on UDRP complaints. She's going to give you recommendations and tips on how to file a good UDRP complaint, but also to defend yourself in UDRP proceeding.
Oh, thank you. Thank you, Marc-Emmanuel. I will definitely try to. There has been a rise in UDRP proceedings, particularly with WIPO, which handled over 6,000 cases last year. So this increase reflects the growing challenges that brand owners face in protecting their trademarks online. Importantly, there are more than 80% of cases that resulted in the transfer of the disputed domain names to the complainants, which highlights the effectiveness of the UDRP procedure in combating cybersquatting. Now time for the quiz of the day. In your opinion, which 3 sectors have filed the most UDRP complaints last year? So take a moment to think. Is it fashion, luxury, banking, finance, internet and IT, biotechnology, retail, food? What do you think? So the winners are, you can go next slide, please. Here you have the top 3. I'm not sure if we should congratulate them. So as you can see, the retail sector followed closely by banking and finance, and biotechnology and pharmaceuticals are among the most affected. But actually, all sectors are affected by domain name abuses, and especially those in fashion, in entertainment, in food, in media, in travel, and many more. Next slide, please. So what are the 3 key elements to prove in a UDRP case? First element, the complainant must prove that they own an identical or similar trademarks which is prior to the domain name registration. By providing, well, official documents like registration certificates or assignment contracts or licenses, depending on the quality of the complainant. Maybe an important note that if you own hundreds or even thousands of trademark registration, you don't need to submit your entire portfolio. Instead, you can present the oldest trademark, so to demonstrate that your mark predates the disputed domain name, and also highlight the geographical scope of your registration. So if you have the trademarks which are registered in China, in Europe, in United States, go ahead, you can show it to show that your mark have a large geographical scope of registration. So it's also recommended to show you when you have registration in the countries corresponding to the domain name extension in question. So maybe to strengthen your case and to prove that the domain name holder could not have been unaware of that your trademark is registered in his jurisdiction. So in some cases, common law trademark rights, so arising from continuous and substantial use of an unregistered sign in commerce, can also be invoked. It's important in such cases to provide solid evidence of real and significant commercial use. The key element of this first criterion is the risk of confusion. So often as a general rule, the GTLDs, well, the extensions in general, they are disregarded, as well as the absence of spaces, hyphens, different punctuation. So to assess the risk of confusion, we try to determine whether the trademark is recognizable in the domain name. So next slide, please. We'll conduct a test to see what we think. Do you believe these domain names are confusingly similar to the following trademarks? So I'll let you a few seconds to think about it. If you think that optimism is can be recognizable in the PNS domain name, etc.
Can I play, Alissia?
Yeah, sure. Everybody is invited. So maybe we can go to the next slide. Thank you. So, well, I'm sure that the complainant had more optimism when filing their complaint, but unfortunately it was true that the optimism trademark is not at all recognizable in the domain name, and the panel considered that abbreviations are not automatically similar enough to cause confusion with the complainant's trademark. So each case must be evaluated based on its specific facts and merits. Well, the second case, Anushka, was found to be close to unauthorised.com. So the panel considers that the omission of the last 4 letters did not eliminate the risk of confusion. And I have to say that this domain name led to a website selling counterfeit products of the complainant, also jewelry designer Anushka Dukas. For in Boursorama case, this dispute also resulted in a transfer. So the panel considered that the element BRS could be seen as an abbreviation of the Boursorama trademark, and this was also supported by the complainant's registration of numerous domain names which contained BRS elements. And the panel also found that the complainant provided sufficient evidence that the defendant used the disputed domain name to impersonate the complainant. For Banco BPM, so that in this case the complainant was a bank, an Italian bank, and defendant used the disputed domain name for illegal website offering banking and financial services under the defendant's name. So the panel ruled that the most distinctive element of the Banco BPM trademark was the acronym BPM, so which has no meaning, while Banco means bank in Italian. So the panel therefore considered that the dominant element of the trademark was recognizable in the disputed domain name and ordered the transfer of the domain name. Finally, for OnlyFans trademarks, there were 2 domain names here. So they led to websites offering adult entertainment services. And the panel concluded that this domain names included the initials of the 2 words forming the famous OnlyFans trademark. So, as you can see, panels may consider the content of the website to assess similarity within the first element. Next slide, please. In the second element, the complainant must demonstrate that the defendant has no rights or legitimate interest in the disputed domain name. So, as this often involves proving a negative fact, the panel acknowledged that it's difficult for the complainant to provide negative evidence. So once the complainant established that prima facie the defendant has no rights or legitimate interest in a domain name, it's up to the defendant to prove the contrary. So how they can do that? By showing one of the following 3 scenarios. So first scenario, it's a good faith use prior to the dispute. So defendant must prove that they were already using the domain name and have actively prepared to use, or had, actively prepared to use it in connection with legitimate offer of goods and services before being notified of the dispute. So to prove that the defendant can present emails or internal documents or invoices or contracts showing their legitimate commercial intentions. So, for example, in the case of VIPO's case concerning the domain name utvpark.com, the panel found that the fact that the disputed domain name reflected the name of seemingly legitimate company which had begun its activities at least 4 years before the registration of the domain name, suggested that the defendant may have used it for a bona fide offer of goods and services. And the panel also noted that it might reach a different conclusion if clear evidence showed that the defendant's initial adoption of the business name was illegitimate. So it's if it was intentionally designed to target the complainant's trademark, and that the registration of the disputed domain name was a part of a larger scheme to target the complainant in fraudulent manner. The second scenario, the defendant can prove that they are commonly known by the domain name, even without owning a registered trademark. So in the mermet.com case, the complainant was a French company specializing in the design and manufacture of high-tech textiles, and the defendant can prove that the domain name corresponded to their surname, and it was used for genealogical research. So the panel agreed that it was legitimate use. Finally, the third scenario, we are always within the second element. So the domain name, if the domain name is generally used for review or parody or informational website with no intention of gaining commercial advantage or diverting customers, this also constitutes the legitimate use. So in this case, I'll try to read it. Anton Bilshik is a fake, something. So the complainant was a doctor specializing in oncology, holding trademark in the United States, and defendant registered the disputed domain name and created a complaint website targeting the complainant, publishing, let's say, unflattering articles about the complainant, which included, among other things, information linking the complainant to the death of the defendant's father. So panel recognized that the website was a non-commercial review platform without advertisement or commercial links, so they acknowledged that the defendant had a legitimate interest. So, of course, to rule on this criterion, the panels notably look for the absence of advertisement or commercial links on the website linked to the disputed domain names. Well, one of the key takeaways regarding the second element, but also the UDRP procedure as a whole, is the importance for defendant to respond to complaints with substantial arguments. So you probably know that in most disputes there is a failure on the part of the defendants, and or at the very least they limit themselves to an unconstructive reaction and fail to provide a clear explanation of their legitimacy in holding and using the disputed domain name, if any, of course. So failing to respond may indirectly work in favor of the complainant, as the UDRP panel may also interpret the lack of argumentation as an admission, a partial admission of bad faith. So don't hesitate to justify a legitimate and non-deceptive use of the domain name. Explain the reason for registering and using the domain name, showing that it's not an act of cybersquatting, and also avoid absurd or inconsistent justification, because they will not, in general, they will not be considered by the panels, and they could even harm the defense. So next slide, please. Finally, a few words regarding the third element of the UDRP, bad faith registration and use. So unlike some national variation, UDRP requires complainant to prove both elements, so bad faith at the time of registration and bad faith in use. A complainant must demonstrate that the defendant specifically targeted their trademarks and that the domain name registration wasn't a coincidence. So the criteria analyzed by panels is the content of the website. So if there is imitation, identity theft, if the domain name registered was registered with the intent to sell it to the right holders or to a competitor, if the domain name is registered and used to divert internet users to a website, if it creates a risk of confusion, if there is a pre-contractual link between, a pre-existing contractual link between the parties, and etc. So I think that we arrived at the conclusion. So next slide, please. As you could understand, first of all, a well-managed portfolio, domain name portfolio. Secondly, an active monitoring. And third, a quick action can help avoid disputes and better protect your trademark online. So to optimize your portfolio without breaking the bank, you should focus on key domains, so those with significant commercial impacts and those that might be used for fraudulent practices. Also prioritize strategic extensions, some like .bank or .finance are more vulnerable to fraud. Also anticipate threats, so cybersquatting, phishing, counterfeiting. It's better to prevent than to cure. And regarding the UDRP procedure, don't forget that the UDRP procedure is not suitable for all types of disputes. So don't hesitate to go to the courts if necessary, and be aware that the UDRP is not a shortcut to acquire a legitimately registered and used domain name. So filing a weak or unfounded complaint can expose the complainant to a reverse domain name hijacking accusation. So when the trademark holder is accused on attempting to seize a domain name by making cybersquatting allegation against the legitimate owner, and which can harm the credibility of the complainant and their representative. I think that we have no time left to answer, maybe a little time to answer your questions. And for the ones we don't have time to answer today, of course, feel free to send them to us by email. We will share our presentations, and we'll be happy to respond. Let's check if
yes, I think there is one for you, Alissia. It is possible to file an appeal against the UDRP decision. So it's a good question.
yes. Well, the question is, it's, you know that UDRP panels can order either the transfer or cancellation of the disputed domain name, so depending on what the complainant has requested. So of course, requesting cancellation is generally not advisable because it doesn't guarantee that the same domain name will not be re-registered immediately. almost by the same registrar. So it's always better to ask for a transfer. So there is no any financial the UDRP panel does not have the authority to award any financial compensation or legal costs, and there is no internal appeal mechanism, at least with WIPO, to challenge a panel decision. So you need to go to the courts, and I think that the respondent have like 10 business days from the notification of the decision to initiate legal proceedings. And if the registrar does not receive the notification of the legal proceeding, they will implement the decision and the domain name will be transferred.
I see a second good one. I think if the domain names holder's information is hidden due to GDPR or privacy services, how can one determine against whom to file a UDRP complaint?
Can take this one as well. So yeah, for GDPR or privacy services, of course, well, actually, it's not strictly necessary to mention the identity of the defendant to file the complaint. So once the center so WIPO or other centers receive the complaint, they will verify the registrant's details with the domain names registrar, and they will also so they will share this information with the center, and the center will notify the complainant about the defendant's contact details, let's say. So and sometimes sometimes new elements emerge following this disclosure, because for example, the respondent turns out to be a former business partner of the complainant, or maybe it is all known by cybersquatting practices. So in such cases, the complainant may want to modify or to add some arguments in their complaint. Sometimes, the complainant may even choose to withdraw the complaint, because we already had the cases where organizations discovered that the domain name was actually registered by another department within the same company, sometimes even located in the same building. So yeah, this highlights the importance of centralized domain name management. So I think that there are so many questions, but we
Maybe we will answer to them by email. It will be easier because we're running kind of late.
Yeah, so I think that we are coming to the end of this webinar, and since it was like the only thing standing between you and your midday coffee, and I'm thinking about our US friends from the United States, or your evening cocktail, we don't worry, we won't keep you any longer. So thank you very much for your attendance and for your participation. Goodbye.
Thank you for your attention.
Thank you.